is 8 o'clock. The Committee on General Investigating will now come to order. The clerk will call the roll.
Chairman Murr.
Here.
Vice Chair Johnson.
Here.
Representative Guerin.
Here.
Representative Longoria.
Present.
Representative Spiller.
Here. A quorum is present. Members, today the committee will hear from invited testimony from committee personnel in Matter A. Because the committee's proceedings in Matter A have been confidential under the above authorities, no public testimony or comments will be taken. At this time, the chair calls Chief Committee Counsel Aaron Epley and counsels to the committee Therese Buse, Mark Donnelly, and Donna Cameron to testify on Matter A. Thank you for being here. I'll turn it over to you, and you can continue with introductions. And then the one thing we'll ask is, obviously, folks can listen from home or wherever they are, so as needed, you will need to move the microphones and speak into the microphone. So thank you.
Thank you. Good morning. As you stated, my name is Aaron Epley. I'm the Chief Counsel and Director for the House Committee on General Investigating. I recently returned to private practice. In March of this year, I was a federal prosecutor with the United States Attorney's Office in the Southern District of Texas. Prior to joining that office, I worked in private practice, and I also worked at the Harris County District Attorney's Office for over 9 years, approximately 9 years, including time in the Public Integrity Division.
And would you just tell the committee which U.S. attorney hired you?
Yes, Chairman, I was hired by Ryan Patrick.
Thank you.
For purposes of Matter A, I'm one of a team of 5. The team is seated beside me and behind me. It's made up of attorneys and investigators with experience in criminal matters, specifically related to public integrity. I would like for them to introduce themselves.
Good morning. My name is Therese Buse. I am a career criminal prosecutor. I spent 25 years with the Harris County District Attorney's Office, handling cases all the way from misdemeanor through the most serious felonies, capital death penalty murder cases. I was twice division chief of the Public Integrity Division, handling crimes against elected officials and public servants. After my career in Harris County ended, I went to Fort Bend County, and I worked under 2 district attorneys there. The second one, I worked with him to create their first Public Integrity Division and worked there for 5 years until my retirement. Retirement didn't last very long. I've done some additional work for Comal County as a special prosecutor handling child abuse, sex crime prosecutions, which is another area of my specialty. And I'm here today to assist with this investigation.
Good morning. My name is Mark Donnelly. For the past year and a half, I've been in private practice. Prior to that, I spent 20 years as a prosecutor. My first 8 years were with the Harris County District Attorney's Office, and at various points throughout that tenure, I worked with the incredible women to my left and right in the Public Integrity Division. After my 8 years at the District Attorney's Office, I went to the United States Attorney's Office and served for 12 years as a United States prosecutor for the Southern District of Texas. At one point, I was assigned to lead the Government Fraud Division, the White Collar Division. I've worked in narcotics, gangs, various types of prosecution, including white collar prosecutions. Prior to leaving the United States Attorney's Office, I spent approximately 4 years as the Executive Assistant United States Attorney and left after serving approximately a year as the Senior Advisor to the Acting United States Attorney for the Southern District of Texas. Thank you.
My name is Donna Cameron. I was licensed to practice law in 1984, 35-year attorney. I have worked 25 years initially in Harris County DA's office. My specialties were public integrity and also white collar, along with violent crimes. I was the chief prosecutor over public integrity and major fraud. Additionally, I became first assistant in Galveston County and handled all different cases, including major fraud, public integrity matters. Additionally, I've been a special prosecutor in Montgomery County. So my experience has primarily been prosecuting elected officials and public servants and looking at major fraud cases.
And Ms. Cameron, when we talk about your work and experience in Harris County, would that add up over a period of 8 different district attorneys?
Yes.
And I think I had asked you that previously. Thank you.
Right. And I would like to introduce the 2 gentlemen behind me. Dan McAnulty, who I've known since the 80s. He was I don't know, did you rise to the level of captain with HPD? And he worked numerous cases there, very many high-profile cases. We were lucky enough at the Harris County DA's office to get him into special crimes, where he worked another 20 years for us. Additionally, he's done some investigative work. He's come out of retirement. I got him to come down to Galveston County to work a very complex fraud case involving elected officials, and that took him a couple of years. And then we've got Brian Binkin, who is a lawyer and an investigator. So he started as a prosecutor with Harris County DA's office. He was there for 8 years. He then went on to become a defense attorney. He then did defense practice until 1991. He became a licensed investigator in 2000, and he has a practice in both areas. He still works as an attorney, has a caseload, and also assists as an investigator. Worked very many high-profile cases, especially in Galveston County.
Thank you, Donna.
Thank you all for being here this morning, and I'll just add, just adding up the years of experience of your service to the public, it's well over 120 years of legal experience sits in front of us today. So thank you for being here. Please continue.
Thank you, Chairman. I would emphasize that despite the fact that you've heard Harris County District Attorney's Office linked to each and every person up here, our careers have spanned such that there is not overlap in a cohesive way in terms of work product or history. We know and respect one another, and there has been some overlap, but we function as a body here of independent counselors and investigators with independent opinions and a voice. However, we have a collective result to offer to this House committee. In regards to Matter A relates to the Office of the Attorney General. I will say OAG for short, as obviously it will be used a number of times over the next several hours. Specifically, Matter A relates to the Attorney General himself, Kenneth Paxton. General Paxton is now, and was at the time of all relevant events, the top law enforcement officer in the state of Texas. His main responsibility by oath and per the OAG website is to defend the state of Texas and its duly elected laws. This includes defending the state of Texas when a state agency wrongfully terminates an employee. The whistleblower lawsuit was filed in 2020. It was filed by 4 employees of OAG from the year 2020, and it relates specifically and solely to the actions of General Paxton. Government Code Title V, Chapter 554.002A states, a state or local government entity may not suspend or terminate the employment of or take adverse personnel action against a public employee who in good faith reports a violation of law by the employing governmental entity or another public employee to an appropriate law enforcement authority. So who are the whistleblowers? The whistleblowers include David Maxwell. David Maxwell was the director of law enforcement at OAG. He had an illustrious career at DPS and the Texas Rangers from 1972 until 2010. He was hired by Greg Abbott, then Attorney General for the state of Texas, and served under him from 2010 until 2016. He remained an investigator and a high-level staff member at OAG under Kenneth Paxton from 2016 until 2020. Next, we have Ryan Vassar, Deputy Attorney General for Legal Counsel. Ryan Vassar was recruited to the OAG in 2015 under Attorney General Kenneth Paxton. Next, we have Mark Penley. He was the Deputy Attorney General for Criminal Justice. Mark Penley was in the United States Air Force. He served 5 years in active duty. He did 16 years of service to the United States Attorney's Office in Dallas, and he was sought out personally by General Paxton. He joined the office in October of 2019. Fourth whistleblower is James Blake Brickman, Deputy Attorney General for Policy and Strategy. He was a former chief of staff for a Republican governor in Kentucky. He too was sought out and hired by General Paxton. General Paxton refers to these individuals as political appointees, and I suppose that's true, but they're his political appointees. Based on interviews and a look at their resumes, each of these 4 men is a conservative Republican civil servant. Interviews showed that they wanted to be loyal to General Paxton, and they tried to advise him well, often, and strongly. And when that failed, each was fired after reporting General Paxton to law enforcement. A settlement was announced in that lawsuit in February of this year. General Paxton agreed to settle on 3 terms. First, he would apologize to the whistleblowers for calling them rogue. Second, he would publicly accept that these men acted as they thought was right. And third, he agreed that the whistleblowers would receive $3.3 million. There are additional results of a settlement. A settlement avoids a trial. A settlement also avoids discovery, the opportunity for both sides of a lawsuit to receive evidence to support or to disprove allegations. As a result of that settlement, neither the terminated employees nor the state of Texas would receive discovery and information related to those charges. This agreement was made prior to approval from the Texas legislature, yet the settlement obligates the taxpayers of Texas, not General Paxton, to pay the $3.3 million for a settlement related to his actions. So in mid-March of this year, the House Committee for General Investigating put together the team of 5 you were just introduced to. The General Investigative Committee empowered us to conduct an inquiry. That inquiry was into the settlement itself, the issues related to the lawsuit, and to make an inquiry into the policies, procedures, and actions of OAG in 2020. We were asked only to follow the evidence, to make an independent, objective inquiry. To that end, to avoid any implication of credibility issues as to the complainants, and frankly, because it was outside of our purview, we made it clear to every person we interviewed that the question before us was not whether or not the settlement should be funded. We did not have control over that. We were asked not to prove and not to disprove the allegations, but to follow the evidence and determine if there was a there.
And just to summarize real quick, so you just laid out to us the basis of the whistleblower allegations in the litigation and the fact that the legislature was asked by a state official to fund a multi-million-dollar settlement into that matter.
That's correct.
Okay.
Yes,
Thank
Chairman. You'll hear from several members of the team today, but first I'd like to address some housekeeping matters and provide you a general outline. The team has reviewed hundreds of pages of records in order to make the presentation before you today. That includes the plaintiff's amended petition, which just means the allegations as laid out by the plaintiffs, those civil servants who were fired, what they allege happened. We looked at codes, laws, court filings, and the settlement itself. We've reviewed emails, notes, reports, organizational charts, and timelines. We've looked at a draft employment contract, City of Austin permitting department records or the absence thereof, the State Board of Texas records, Texas Ethics Commission records, Texas State Security Board records, and campaign donations. We have reviewed complaints of criminal activity, depositions, and opinion letters. We have reviewed grand jury subpoenas. We have also reviewed in detail what we have come to refer to as the OAG report. This document is about 370 pages in length. It was posted on the OAG website in the fall of 2020, almost immediately after these events. It's a formalized response from General Paxton and his office regarding the whistleblower allegations of wrongdoing. That report references a commitment for ongoing investigation and supplementation. To date, there have been no amendments and no supplements to that response. This team also conducted 15 interviews of people directly involved and many additional conversations to provide context and to provide background. We've interviewed the whistleblowers, David Maxwell, Ryan Vassar, Mark Penley, and Blake Brickman. We've interviewed Josh Godby, who worked in the Open Records Division, 5 senior or high access employees with OAG in 2020. As a caveat, I would make the request that you not inquire as to the first and last names of these individuals at this time. They did not put themselves into a public forum. They did not participate in a whistleblower lawsuit. And to have their information in the public opens them up to pressure, political ridicule, harassment. It also has a chilling effect on witnesses going forward. To that end, I will tell you that without exception, that's not true. I will tell you, out of the 15 employees, only one did not express grave concerns as to hostility or aggression in regards to their conversations with us and fears of retaliation.
Would you just clarify that again? You said of nearly every single person that your team interviewed as part of this process, that nearly every single person expressed fear and concern about retaliation from Ken Paxton?
Independently, based on their own knowledge of the facts and the circumstances leading up to their presence in our office or on the phone, that is absolutely accurate.
Thank you.
We also interviewed Margaret Moore. She was the elected district attorney in the Travis County District Attorney's Office in 2020. Don Klimmer, Chief of Special Prosecution at the Travis County District Attorney's Office in 2020. Greg Cox, previous Director of Public Integrity at the Travis County District Attorney's Office. You'll hear that Mr. Cox also returned to the Travis County District Attorney's Office to look into a bribery investigation involving Kenneth Paxton after the whistleblower allegation. We interviewed Ray Chester, an attorney with the Mitty Foundation, a charitable organization that functions here in the state of Texas, and that the Attorney General's office would have an obligation to protect. Brian Weiss, special prosecutor in regards to the security frauds cases, and various attorneys on related matters, various state agencies. By way of an outline, we will first address the concerns as expressed by the whistleblowers in the suit and in person, as well as concerns from other senior staff who are involved in these events. Next, we'll discuss the current felony indictment pending against General Paxton. That case is still pending after being filed in 2015, and as we all know, relates to the security fraud issues. Third, we'll discuss the whistleblower lawsuit itself. The lawsuit has 4 primary allegations, each from different divisions of the office, each, at least at the beginning, involving separate people from one another, and all in the exact same time frame of 2020. Allegation 1 is that General Paxton directed actions against a charitable organization in Texas. That charity is the Mitty Foundation, and that these actions were to benefit a donor.
Would you spell Mitty?
Yes, Chairman. M-I-T-T-E.
Thank you.
Allegation 2 is that General Paxton directed actions against the standard law enforcement protection afforded to ongoing investigations. He did this to benefit the same donor. Allegation 3 is that General Paxton directed action outside of law enforcement protocol and investigation on baseless allegations, that the investigation was done by a person outside the Office of the Attorney General and supervision there, save one that they reported to Attorney General Ken Paxton. That this investigation was outside of the Office of the Attorney General's jurisdiction, and that it resulted in unlawful actions for the benefit of the same donor. Finally, we will speak to the big picture, how this all fits together and how it was resolved. We'll take a look not just at the individual actions, but at the overall context in which it occurred. I ask that we look at the pattern and deviations from the norm, questions not just of criminal activity, but also of ethical impropriety and transparent or lacking transparency of action. I'd ask that you consider who benefits. We'll address the retaliation by General Paxton towards those that acted as they believed was right. The interviews suggest and the settlement implies that they made a report they believed was necessary, ethically required, and legally obligated to make. And they were fired. Finally, we will provide a sample of the statements from the Office of the Attorney General report that interviews and documents suggest are false or misleading. That brings us to the first piece. Concerns of the whistleblowers and other staff related to General Paxton in 2020. As any lawyer will tell you, motive is not something that we're often required to prove in court. How can you know why another person has done what they've done? That said, our focus was on the whistleblower allegations in regards to wrongdoing at the Office of the Attorney General and in regards to General Paxton. We would be remiss not to inquire into the current concerns as articulated by those employees and questions as to the concern and context for what happened. This team's goal was not to judge the personal life of another, especially in this forum. But our role was also not to ignore pressure points, opportunities for compromise, and places where benefit could be derived. All 4 allegations made by the whistleblower revolve around a person named Nate Paul. He is the donor I referenced in allegations 1, 2, 3, and 4. So who is Nate Paul? Nate Paul is an Austin real estate developer and the CEO of a company called World Class Holdings, World Class Capital, and various iterations of the same. As context, in 2017, a Forbes article estimated that Paul's portfolio of commercial properties was worth over $800 million. It is possible that that number was overstated. By 2019, the Austin Business Journal reported at least 18 of Paul's companies had declared bankruptcy. By 2019, Nate Paul was entangled in lawsuits and facing as many as 13 foreclosures by 2020. A great deal of that information is available at a Google search at the time of these relevant events, and you will hear that various staff members inquire as to who Nate Paul is and are able to locate information similar to what I have just described to you. Second, Nate Paul contributed $25,000 to General Paxton's campaign fund in October of 2018. Emails and interviews established that Paul and the Mitty Foundation were headed towards litigation. Portions of the OAG report speculate as to how could Nate Paul possibly have known he was going to end up in litigation. Ms. Boos will talk to this in more detail, but there is an absolute overlap in regards to the direction they're headed and the likelihood for litigation when that donation is made. The OAG must, by law, be notified when any lawsuit impacts a charitable trust, and they were. By December of 2018, Mitty has sued World Class Holdings and Nate Paul. In August of 2019, a search warrant is executed. A criminal search warrant is executed by DPS and the FBI on property belonging to Nate Paul. In the spring of 2020, an executive staff member was notified that General Paxton was bypassing security detail. Instead of using that security detail to come and go for meetings, he would use a staffer. Additionally, they were notified that Attorney General Paxton would leave meetings off his schedule entirely. Second time this happened, the staffer was asked who General Paxton was meeting with, and the answer was Nate Paul. There were several lunches with the young staffer present between General Paxton and Nate Paul in 2020. The lawsuit also referenced that General Paxton was having an affair and that by 2020, the woman was working for Nate Paul. The inquiry developed evidence, conversations that were overheard, as well as conversations directly with General Paxton that support that an affair was known to staff. I do not say this to sully, but to provide context because the woman ends up working for Nate Paul. The affair was not public. There was a desire to keep it private, according to these interviews. And the interviews establish that now Senator Angela Paxton learned of the affair in 2019, that the affair ended briefly, but then it resumed and was underway again by 2020. A deposition of Nate Paul in regards to the Mitty lawsuit also establishes that Paul met the woman through General Paxton. Nate Paul admitted that she worked for one of his companies. However, he did not know how much she was paid and could not identify a single specific project that she worked on. In addition, General Paxton's home was renovated in 2020. Interviews from people who were present at the house and those who corroborate the timing of those original events establish the following. There was water damage in the home that caused a need for repairs. That repair progressed into a full renovation of the home, floors to ceiling. An OAG employee was present for at least 2 conversations in which General Paxton indicated that he would like upgrades to the home. One conversation was specific to granite countertops. General Paxton relays that now Senator Angela Paxton did not like the counters and wanted to change them. The contractor advises that that upgrade will cost $20,000. General Paxton indicates that he'd like to proceed, and the contractor, according to the employee there's response, was, "I'll have to check with Nate." Not alleged by the whistleblowers, but on the same theme, an inquiry found evidence of a dereliction of duty and of a lack of transparency. Specifically, a failure to disclose information that General Paxton had a duty to disclose. The Texas Ethics Commission is responsible for collecting information that the state of Texas has determined relevant in regards to transparency for public officials. The Texas Ethics Commission records established that General Paxton had failed to report his connection to boards and his receipt of various gifts. General Paxton has supplemented or amended filings for failure to disclose once those discoveries were made by other parties. The failure to register and securities fraud will be covered as well. But for context, those are related to an additional donation made to General Paxton. Once the securities fraud cases are charged, and because they predated his time as Attorney General, campaign funds cannot be used for that defense. So Attorney General Paxton creates a defense fund.
Ms. Epley, may I ask a question? You said that there was another donation, and you said it was related to another amount of money. Is this another amount of money to General Paxton from Nate Paul or from somebody else?
Thank you, Vice Chairman. It is a $100,000 donation, from another donor specifically to his defense fund, not Nate Paul. The contribution was made to the defense fund in the amount of $100,000. The donor in question was under investigation by state and federal authorities. Attorney General Ken Paxton did not decline based on a conflict of interest. General Paxton did not report the donation as required. He later explained there was no duty to report because it was a gift. So the question is, was there a conflict of interest? That donor later settled litigation. They agreed to pay $3.5 million on allegations that they improperly billed the state government for Medicaid and Medicare services performed without the appropriate medical supervision, violating state laws, according to the United States Attorney's Office for the Northern District of Texas. What's significant here is that the Attorney General, as the head of the Office of the Attorney General and the primary defender of the state of Texas, would be involved in that litigation. That investigation began in 2009. Therefore, these events were ongoing when the $100,000 donation was received. That brings us to the securities fraud. Background will be helpful here to help explain why a person in Attorney General's position would understand the law and why his actions are alleged to be a violation of the law. As most prosecutors will tell you, or any prosecutor will tell you, ignorance of the law is not a defense, but I do think we collectively think that it's important to look into what General Paxton knew about securities regulation. First, General Paxton graduated from law school in 1991. On August 1st of 2001, General Paxton sat for an exam as required by the state of Texas in regards to security, his regard for his license, and he needed to have a passing grade. Passing grade is 70. General Paxton's score was 92. In 2002, General Paxton was elected to this body, the House of Representatives, and on May 1st of 2003, then Representative Paxton was able to vote for Senate Bill 1060. What is Senate Bill 1060? It's a bill that makes it a felony for a person to render services as an investment advisor or investment advisor representative without being registered. This bill protects transparency, This bill protects transparency in the market, provides an understanding of a salesman or investor representative advisor's motive and protects the public trust in the market. Kenneth Paxton voted on that bill. In July of 2003, Attorney General Paxton registers as an advisor representative, indicating knowledge of the law and its requirements. He did this in regards to a company that would later become known as Maori Capital. But when Paxton's registration ends in December of 2004, evidence suggests that he continues to work as an investment advisor representative. That is to say that General Paxton solicits investors for Maori without registering with the state board. The relationship is that in exchange for bringing investors to the business, General Paxton receives 30% of the management fees for his referrals of investors in regards to the stock. That is legal and perfectly fine. The law simply requires or expects a duty of disclosure. Here the problem is General Paxton did not tell the investors about the relationship, and he did not tell the Texas State Securities Board. Interviews and records established this happened in 2004, in 2005, and in 2012. Interviews and records also indicate that General Paxton did not
Paxton
disclose
maintained
the income
control
on his taxes
and
nor
custody
report
of
the
that
connection to
file
the Texas
for
Ethics
7
Commission
to 10
as
days.
required as a state representative. These issues were not corrected nor addressed by General Paxton until after a journalist uncovered the issues. There is evidence that in the spring of 2014, an investigative reporter poses questions to the Texas State Securities Board about General Paxton's relationship with Maori, about a failure to register, and about fee sharing. The reporter provides the Texas State Securities Board with a lawsuit from 2009. That lawsuit was against Attorney General Ken Paxton, where investors complain of the very situation I just explained to you, acting as an investment advisor with a fee-sharing relationship without making disclosure and without registering. Soon after questions are posed to the government agency, General Paxton's attorneys arrive or address the Texas State Securities Board in regards to General Paxton and in regards to Maori Capital. By the time the Texas State Securities Board addresses the matter, the statute of limitations has passed. The statute of limitations is a limitation on prosecution. If a statute has run, prosecutors are unable to proceed with criminal charges regardless of how valid the meeting of those elements or the proof in that case might be. General Paxton has admitted that he had a duty to register and did not meet that duty in regards to the 2012 events. He agreed to a reprimand from the Texas State Security Board and paid $1,000. There are options for people to proceed under purely administrative functions or criminal charges. The question would be, relevant to most prosecutors, would be, did you know better? A formal complaint was then sent to the Travis County District Attorney's Office. At this time, a second company is relevant in regards to an investigation into General Paxton and securities fraud. While still in the House of Representatives, Paxton became affiliated with a company called Servergy. The CEO of that company had donated to Paxton's campaign, and by 2011, the two men decided to do business together. In July of 2011, the CEO of Servergy offers General Paxton a 10% commission. It's perfectly lawful. The 10% commission is on stock sold, and the email response of General Paxton is, "I'll get to work." On July 22nd of 2011, Paxton brought 7 people into the Servergy office, potential investors willing to contribute their money if it looked like a good deal. General Paxton also had 5 more investors contacted for a sales pitch by telephone or email that same day, 11 days after saying he would get to work. There are allegations that Representative Paxton used pressure tactics to sell the stock. For example, that he called a potential investor late at night who had passed on the opportunity. General Paxton calls. The purpose is to try to get this individual to invest, to change his mind. And General Paxton tells him that he expects the prices are about to go up. There are allegations that General Paxton was included in conversations or emails where the company made misleading or false statements in order to induce potential investors. Representative Paxton was successful in recruiting investors. SEC filings show that Paxton sold $840,000 worth of stock in Servergy in a month. Per the terms of that prior addressed email, that would be a commission of $84,000. On August 5th, 2011, General Paxton received 100,000 shares of stock valued at $100,000 from the CEO of Servergy. That is okay and perfectly legal. But these facts, according to the special prosecutors, are material to investors. And Attorney General Paxton failed to disclose that he would be compensated by Servergy in the form of 100,000 shares of Servergy stock, and that the defendant, Attorney General Paxton, had not and was not investing his own funds in Servergy Incorporated.
Ms. Epley, can I interrupt you just summation? So you just told us, and I don't want to dwell on it because you'll have a lot of material, but you just told us that there were multiple instances that now the statute is passed where Mr. Paxton did not register with the State Securities Board, actually acknowledged that, paid a fine, and then turned around and proceeded to continue with the same pattern of behavior of not registering and interacting in those transactions for personal gain?
Yes, I would, one qualifier. There's evidence that he did this in 2004 and 2005, was put on notice of the violation in 2009 because of a lawsuit, and did it again in 2012.
Okay, thank you.
Yes. The question here is whether or not it was a gift. If it was a gift, there are different disclosure requirements. The argument in regards to the prosecution is that it was a commission. So what is a commission, and was there an agreement? There was a written agreement signed by General Paxton which provided that shares or an ownership interest in the business would be provided in exchange for, quote, services. General Paxton later says the stock was a gift. He did not report that to the Texas Ethics Commission as a gift. Also, the storyline, though, in regards to the difference between a commission and a gift, or the version of facts put forth, is that General Paxton met the CEO at a Dairy Queen. He intended to pay for and to buy the stock, the 100,000 shares. However, the CEO stated that God had directed him to give the stock to Attorney General Paxton, therefore substantiating that it was in fact a gift. However, Servergy documents created at or after the issuance of the stock indicate that the stock was, again, for, quote, services. That brings us to the Travis County District Attorney's Office and the referral mentioned earlier. ADA Greg Cox was the division chief over public integrity. He reviewed the allegations and charted a path forward. ADA Cox met with law enforcement, reviewed the documents, and determined that there was sufficient evidence to proceed with the charges. ADA Cox had a belief that he could prove the elements of this offense beyond a reasonable doubt. However, a change in state law meant that Travis County could not prosecute the offense. The law required that it be prosecuted, if at all, in Attorney General Ken Paxton's home county, that is Collin County. So a referral was made to that venue. In January of 2015, the same month that General Paxton was sworn in as Attorney General, the case was referred to Collin County. By then, General Paxton was not only the chief law enforcement officer, he was also friends and business partners with the elected DA in that jurisdiction. The Collin County DA appropriately recused himself. That is, he said that someone else needed to prosecute the case because of his connections to Attorney General Paxton. It's for this reason that in 2015, Special Prosecutors Kent Schaefer and Brian Weiss were appointed to represent the state of Texas. An indictment was filed in July of 2015 and later amended. There are 3 counts currently pending against Attorney General Ken Paxton, 2 for securities fraud in regards to Servergy. That is the failure to disclose material information to the investors. It is a first-degree felony, and it carries a punishment range of 5 to 99 years or life. I've recently learned that one of the complaining witnesses in that case has passed away. The state of Texas can and will decide how to proceed in regards to those matters. But I would point out to this body that there were other individuals who could have been listed as the complainants on those cases because it wasn't done at the time. Again, the statute of limitations has run, but it doesn't change the underlying facts of what we're explaining to you. Count 3 is failure to register. This is in regards to Maori Capital. There's a failure to notify the Texas State Securities Board. It's the 30% management fee discussion. The punishment range on a third-degree felony is 2 to 20 years in prison. Those cases are still pending 8 years later.
Oh, those cases are pending 8 years later. Could you explain to this committee just briefly why those cases are still pending 8 years later?
Yes, Chairman, I can make an attempt to do that. If you look at the case filings in regards to the securities fraud, it is clear that the defense makes many filings. A defense attorney's job is to zealously advocate for their client, and in no way am I besmirching them for having made the filings. But each one of those filings creates the need for a response, if any, a potential hearing and a ruling, and they come one after another. Of particular interest are 2 different lawsuits. Those are not by defendant or his counsel, but information suggests that a donor and friend of Attorney General Paxton is responsible for a lawsuit challenging the fees paid to the special prosecutors. Those issues are still outstanding.
Was there also some challenges with venue, and they've moved the venue back and forth from a couple of different counties?
Yes, Chairman, if I were to recap that situation, the investigation begins in Travis County, who does not have venue. It's not proper to prosecute there, so it is sent to Collin County. The Collin County District Attorney recuses themselves, says that they shouldn't proceed, and special prosecutors are appointed. Documents would show and conversations show that the special prosecutors believe they cannot get a fair trial in Collin County, given General Paxton's connections there, and they move for a change of venue to Harris County. That is granted. It proceeds. Litigation is filed again, saying that venue is proper back in Collin County. That is ultimately granted. Case is returned to Collin County, and then additional litigation in regards to the fact that special prosecutors still believe the proper venue is Harris County. Both those issues, venue and payment, are pending before the Court of Criminal Appeals.
So the issue's always been about payment and venue, and they haven't ever had an opportunity to get to those facts in those cases.
That's, yes.
And more succinctly, Mr. Paxton has never testified or offered deposition testimony or other sworn testimony in 8 years of those litigated matters.
That's correct.
Okay.
And next, I would turn it over to Therese Boos.
Thank you, Ms. Epley. We're going to now move to the whistleblower complaints, the allegations that they made. I'm going to cover the first 2 of those. The first one is the open records request. And I know that all of you, as people that work within government, are familiar with the requirements of the Texas Public Information Act, which is Government Code Chapter 552. And the fact that the Office of Attorney General is the agency tasked with the responsibility of determining ultimately what information has to be turned over. So we all know typically we'll receive a request for particular information. If it's something that we as government employees or agency affiliated folks don't want to turn over for various reasons, all of that information gets bundled up and sent to the Office of Attorney General. There are strict timelines that apply to getting that information to the OAG. The OAG is under guidelines as far as a time frame for their response back. The OAG receives over 30,000 requests annually to make determinations as to whether information has to be released or if it falls within one of the statutory exceptions for disclosure. And the reason we do that in the government is we want one entity to be responsible for maintaining uniformity in the application of the Public Information Act. One standard exception to the requirement for transparency in government is the law enforcement exception. It shields information that is developed and held by law enforcement agencies or prosecutors. It deals with the detection, the investigation or prosecution of crime, and that release of information would interfere with the detection, investigation, or prosecution of criminal activities. Obviously, law enforcement agencies working on these kinds of things don't want the targets of their investigations to know what they know. In December of 2019, General Paxton asked his Deputy Attorney General for Legal Counsel about a disputed open records request that had come from a Dallas law firm on behalf of Nate Paul. The Texas State Securities Board, in cooperation with the FBI, DPS, and other federal and state law enforcement officials, had executed search warrants at the businesses and the residence of Nate Paul in August of 2019. Paul wanted access to the search warrant affidavit of probable cause. There's two sets of paperwork when we talk about a search warrant. There's the general form that's handed to a person when you're entering their home. And then there's what we call the affidavit of probable cause. It contains all the details, the facts, the information that's been developed that is presented to a judge, a magistrate, for signature for authorization for that search. And it contains all of the details to get us to that front door. Paul wanted access to that information, but it was under court seal, and it fell under the law enforcement exception, under 552.108 of the Government Code. So Attorney General Paxton brought that file to his Deputy Attorney General for Legal Counsel. He asked him to look into it. General Paxton told him he thought it was unfair that Nate Paul could not have access to his own search warrant information. He stated that he too had experienced unfair treatment from law enforcement. The deputy Googled Nate Paul because he was curious why the interest in this, and he realized that he was under investigation from the FBI. He read about the execution of the search warrants. He also saw that Nate Paul's businesses had multiple bankruptcies, and he was concerned. The deputy told us that normally when General Paxton was provided with a well-thought-out explanation with legal precedent, he did not push back. But this time he was not happy with the determination that the records should not be released. He asked for a copy of the Open Records Handbook. That's something that's online and available for anyone to take a look at. He also had a lengthy meeting with the Open Records chief. Ultimately, the determination was made not to release those records, which was the correct one under the law. While it was not uncommon for General Paxton to ask about an opinion, this was the first time that he had ever taken such a directive interest in an open records request file, according to this deputy. There would be two more times, each involving the same type of information underlying the search warrants that were executed at Nate Paul's businesses and property, and which pertained to that ongoing criminal investigation. In March of 2020, Attorney General Paxton requested that Ryan Vassar, then the new Deputy Attorney General for Legal Counsel, he was over the Open Records Division, he asked that he obtain a particular open records file. It was a request that had been made to DPS for their records concerning the search of Nate Paul's properties. I'm going to call this the second request. The FBI, since their information was also contained within the DPS records, also filed a joint request not to have that information released because their investigation was still ongoing. So both DPS and the FBI sought to shield from disclosure any of that information and they provided unredacted copies of what they wanted shielded as part of that process. As part of that process, a redacted copy of that information is sent to the requester. Over the course of several meetings concerning this matter, Vassar informed General Paxton that the law enforcement exception was pretty black and white, and the documents were not subject to disclosure. To release them was going to violate the terms of the law and years of legal precedent. It was going to force law enforcement agencies to sue to try to protect upcoming information. And it would also impact the the Office of the Attorney General, which on its own also has some responsibilities for conducting criminal investigations in certain areas as well. General Paxton told him that he had spoken with Nate Paul, and that he was being railroaded. He said he did not want to use his office, the OAG, to help the feds or DPS.
Hate to interrupt you. Did you just state, I want to be very clear, that the Attorney General for the state of Texas said he did not want to use his office to help law enforcement?
That is exactly what was relayed to us.
Okay.
At a subsequent meeting concerning the second open records request, General Paxton requested that file from Vassar, and the full file was handed over to the Attorney General's aide to deliver to him. Paxton maintained control and custody of that file for 7 to 10 days, and that file included the unredacted documents.